Baldwin, and I'm a member of BASIF's Marriage Fairness Task Force. And there have been so many people who've stepped up around the marriage case from the beginning, and we have two of the real leaders on this issue sitting up here. But before we turn it over to them, I just wanted to point out that within this community, especially this legal community, there has been an incredible amount of energy that has been spent on No 1-8 since this issue started emerging right after the decision. And we're so lucky to have Dan Burkhart as the head of our bar association here. He has led our bar association around this and has done such an incredible job at recruiting a lot of the organizations that are on and participating in our Unity Coalition. And if you would take just a moment to look at this list, which grows every single day, it's incredible. And Khurshid Khoja, who's one of our co-chairs, has also done an incredible job at reaching out to these bar organizations and getting them to sign on. And it means so much to have, for example, the Iranian American Lawyers Association, the Bay Area Muslim lawyers standing up against Prop 8. It's just incredible what we've been able to do. And this is just the start. And that's partly why you're all here, because this is a leadership workshop. What we want this workshop to do is to arm all of you with the information that you're going to need to go out and carry this work into the community, whatever community you operate in, you work in, you have contacts with, and we're so grateful that all of you could make the time to come. So let me first introduce Donna Ryu, who is a professor at Hastings, and she is a board member of NCLR, and she's been working on this issue for a long time. And then next to her is Kate Kendall, who's the executive director of NCLR and an absolutely inspiring leader for all of us. And I know you all know her already, but here she is live in person and helping us as we move forward on this.
You can see me, you can hear me. Well, it is great to be here, and because it is clear that in this fight, where so much is at stake, and that's so enormous, and where so much hangs in the balance, to have leadership from Mary and from the legal community, this is kind of showing that this is why I went to law school. This is why we went to law school. This is the change we want to be a part of making. And so I want to thank Mary for her leadership and the Marriage Task Force. And I also want to acknowledge another hero that brought us here to this historic moment, and that's Bobby Wilson with Howard Rice, who was part of the legal team with the city of San Francisco that brought us the victory. Thank you, Bobby. Now, I know there's probably not a person in this room who has not read in Ray marriage cases the ruling from the California Supreme Court. And if you haven't read it, let me just say, you've got some reading to do. And it is the sort of reading that you don't have to be a lawyer to understand or appreciate. It should be shared with anyone who cares about the rule of law and equality and fundamental fairness and human dignity. Matt Coles, I was on a panel with Matt Coles, who is the director of the ACLU's LGBT and AIDS Rights Project in New York. Matt, one of my mentors and a longtime legal hero to all of us, was on a panel with me at Lavender Law, which was in San Francisco this past weekend. Many of you probably attended some of it. And Matt, who has seen many, many rulings involving the lives of LGBT people in his very storied career, said that the ruling from the California Supreme Court in the marriage cases was the single most important ruling for the lives of LGBT people in this country in our lifetime. In any court, anywhere, any country in the world, is essentially what he said. And it's the sort of ruling that has the potential to completely change future generations and the way people are regarded under the law. And I think because we all understand the enormity of the ruling, that it's not just about marriage, although, of course, that's the big headline grabber, ending the exclusion of lesbian and gay couples, same-sex couples, from the right to marry. But for all the legal wonks, the thing that we were most struck by in the ruling, and I don't know about you, Bobby, but I would have bet money and lost that the court applied strict scrutiny to sexual orientation and to laws that discriminate on the basis of sexual orientation. No high court has ever done that in the history of our movement and our pressing of our legal claims. It is history making. It is future transforming. And what a privilege to be here to see it. To be here to see it, to read it, to be a part of it. It is our legacy. And it is in peril. Because, as we all know, at the very same time, lawyers were preparing the briefs. Our opponents were gathering signatures to put a constitutional amendment on the ballot that would they'll now eliminate or prohibit or ban the right of same-sex couples from marrying in California. It wasn't enough to get the statute that they got through Prop 22 in 2000, also known as the Knight Initiative, which we've heard the drumbeat of, won with over 60% of the popular vote in California. But you know what? 8 years is a lifetime when it comes to issues like this. And in that lifetime, people's views have changed. The legislature in the state of California, not once but twice, passed a marriage bill. And then the California Supreme Court, a Republican-dominated Supreme Court, in an opinion authored by a Republican-appointed Chief Justice, ruled that not just marriage was a fundamental right, that everyone should grow up knowing that they will have the right to marry the person that they love, but that any laws that discriminate on the basis of sexual orientation will be subjected to the most rigorous scrutiny. The ballot measure qualified. They gathered their signatures. At about the same time we were winning this landmark victory, we understood that we were going to be facing a ballot measure in November. Not just a ballot measure, not just any kind of ballot measure, but a constitutional amendment. That now, with its new title and summary, and with its effect, is intended to eliminate everything that ruling stands for. Now, I understand all the legal, the lawyer minds, I can see that, well, it wouldn't really eliminate the strict scrutiny portion, would it? You know what? Save me the technicalities. You all know what we're talking about here. The atmospherics of a loss would certainly eliminate the right to marry, would embolden our opposition, would give them exactly the momentum they need to move forward on every other issue that they've attacked us on for generations. School stuff, kid stuff, employment stuff. We have the potential a year from now to win marriage in 6 other states. Well, you know what? If we lose in California, that is not happening. If we win, in a decade, we could live in an entirely different country when it comes to the rights of LGBT people. If we lose, it'll be my kids' kids that maybe will be the ones who benefit from the fruits of 3 more generations of work. We are not going to let that happen. So,